Hello everyone, thank you so much for joining us today and welcome to our webinar. My name is Alina Kay and I'm one of the solicitors here at EI Legal. As you'll know, the purpose of today's webinar is to take everyone through some of the key provisions in the legislation around bullying, discrimination, harassment, as well as Vesture's grievance handling policies and how those will apply to each of you in your roles. So this slide is just an overview of some of the things we'll be talking about today. Obviously the focus of today's webinar will be bullying, given that there have been some quite significant changes to that jurisdiction as of 1 January this year. However, we'll also be touching on those closely related matters of discrimination and harassment, as well as grievance handling, which covers all of those three first areas. So if I just take everyone now through an overview of the bullying part of today's webinar. The first thing we'll be looking at is kind of one of the big questions, which is what will the Fair Work Commission consider to be bullying? What falls in the jurisdiction and what falls outside of the jurisdiction? The second thing we'll be looking at is who will be entitled to bring a claim of bullying. So what we'll see in today's webinar is that the jurisdiction is not limited, as other areas of employment law may be, to the traditional employee-employer relationship, but extends to workers, which is a much broader definition, and we'll look at that further shortly. After that, we'll be looking at the types of remedies that workers can seek from the Fair Work Commission if they bring a claim in relation to bullying in that jurisdiction. And then finally, we'll be looking at steps that Vesture can take to prepare for the new jurisdiction and really tailor the training session to the way that the business operates. So to start off with a little bit of background, as some of you may have seen, it was quite widely publicised. On the 1st of January 2014, the Fair Work Commission was given new powers around bullying under the Fair Work Act. Prior to 1 January, there were still avenues for employees and other workers to pursue bullying claims. However, these had always been heard in connection with other types of matters. So matters such as work health and safety, adverse action claims under the Fair Work Act, discrimination claims, workers' compensation claims for work injury damages, and also bullying claims were traditionally tied into common law claims for breach of contract. So what we're seeing now is the first time in Australian history that there's a standalone avenue to pursue bullying claims. And I think that that's one of the reasons why today's webinar is particularly important in terms of everyone having an understanding of what that jurisdiction means and how Vesture has taken steps to protect employees and other workers from claims of bullying. In terms of the scope of the jurisdiction, I thought I'd just share a quote with everyone that one of the commissioners at the Fair Work Commission has said in a press conference. So she said, "We weren't sure whether the new anti-bullying jurisdiction was going to be a fizzer like Y2K, or whether it was going to be more like a tsunami hitting us." And what we found really is that although there's been one decision in the new jurisdiction, at this time, many of those matters have kind of settled prior to going to the decision or the hearing stage at the Commission, although there is data out there saying that the Fair Work Commission's bullying helpline has already taken 200 plus calls a week. So if we turn now to one of the major questions, which is, what is bullying? Bullying will take place where, firstly, a worker is at work. So the most common example of that would be an employee going to their place of business every day. The second bullet point there on that slide is where the worker works for a constitutionally covered business. So a proprietary limited company would be included in that. And where the behaviour creates a risk to health and safety of that worker in the workplace. One of the things that slide touched on is a question of who is a worker. So who will fall within this extended definition, which goes beyond the traditional employee-employer relationship? Some of the other people in the workplace who would be considered workers and fall within this jurisdiction are contractors. So an example of that might be if a business has a cleaning contractor come in to clean the offices every night. Another example is subcontractors. So if that cleaning company subcontracts some of that work to someone else, a particular type of the cleaning work, for example. The definition of worker also covers students gaining work experience in the workplace. So whether those are sort of unpaid internships or paid work experience. When we're looking at what causes a risk to health and safety and some of and conduct that may constitute bullying and conduct which will fall outside of the scope of bullying, it's quite good to look at that in terms of 3 criteria. So the first is that the behaviour has to be repeated. The second is that the behaviour will need to be unreasonable. And the third is that it causes a risk to health and safety. So if we look first at what repeated behaviour means, this kind of refers to the persistent nature of behaviour. So it can, in that sense, refer to a range of behaviours over time, which are in many ways related. The second criteria there is unreasonable behaviour. So behaviour that a reasonable person, an ordinary person having regard to all the circumstances, would see as unreasonable. To help understand these 3 criteria better, I thought it would be good to take you through a Fair Work Commission decision which was handed down earlier last year, not in the context of the bullying jurisdiction, but in an unfair dismissal context. The reason why the case is useful, although it wasn't brought under this bullying jurisdiction, is because the Fair Work Commission made some comments about the type of behaviour and the severity of the behaviour which would need to be established in order to show that bullying has occurred. So that case of last year was Harris and Workpac. In that case, the Fair Work Commission indicated that it will not automatically assume that an employee's hurt, humiliation or embarrassment has been caused by bullying. So what happened in that case was the applicant was Ms. Harris. She'd been working for Workpac for a number of years, and during that time she'd worked with another staff member called Rachel May. When Ms. May resigned, and that resignation happened in December 2012, during her exit interview, she indicated that she'd been subjected to bullying by Ms. Harris and made allegations that Ms. Harris had allegedly sworn and screamed at her, consistently embarrassed and humiliated her in front of others, and complained about her to get her into trouble. Ms. May, when she resigned, asserted that she had not made these complaints at a time earlier to the resignation. She had made these complaints at a time earlier to the resignation, but that the employer at the time had not acted on them. So it's only when the employer heard about this at the time of the resignation and not before, when the complaints had been raised, that the employer decided to take action. After Ms. May resigned, Ms. Harris was informed that she had to attend a meeting the very next day about her alleged treatment of Ms. May. Ms. Harris attended the meeting in which she denied all of the allegations. So that meeting concluded at 11:30 in the morning, and then only some hours later at 2:30 p.m. on the same day, Ms. Harris was informed that she was going to be terminated immediately for bullying Ms. May, and that bullying constituted gross misconduct. Following her termination, Ms. Harris made an application to the Fair Work Commission, which is where the decision came from, and in that application she was seeking a remedy for unfair dismissal, saying that her dismissal was unfair in many ways because she hadn't been given a proper opportunity to respond to the allegations. So in the decision, the issues that the Commission was required to consider were both related to whether the allegations of bullying were substantive grounds for dismissal. Two aspects of that consideration were, firstly, did the conduct actually occur? And secondly, did the conduct have the effect that was alleged by Ms. May? in other words, a bullying effect. The Commission was quite critical of the fact that 5 of the 7 incidents complained of were 17 months old at the time Ms. Harris was terminated. The Commission also noted in relation to some of the allegations that it wasn't uncommon to swear in that particular workplace, and at the time Ms. Harris was going through some distressing personal circumstances which she'd raised with the employer. The Commission was also critical of the fact that the incidents which were alleged had been poorly documented. Ms. May said that she had kept a notebook of the events, and she said that this notebook existed in the termination meeting, but the notebook was not tendered as evidence in the unfair dismissal, and it was not referred to in Ms. May's statement either in the unfair dismissal claim. The Commission went on to say that there was no record of the verbal complaints that Ms. May said she'd made prior to the resignation, and that there were problems in the way that the employer had conducted the disciplinary investigation from a procedural perspective, in that the employer had not given Ms. Harris details of why the employer had formed the view that Ms. Harris was guilty of bullying. In this context, the Commission made the following comments. In my view, the Commission should guard against creating a workplace environment of excessive sensitivity of every misplaced word or conduct. The workplace comprises of persons of different ages, workplace experience and personalities, not divine angels. Employees are required to pursue inappropriate behaviour, but need to be mindful that every employee who claims to have been hurt, embarrassed or humiliated does not automatically mean the offending employee is guilty of bullying and gross misconduct. So what we can take from this case is the importance of really conducting fair investigations following company policy around allegations of bullying. And we can also take away the fact that the Commission will approach bullying matters cautiously moving forward. So in light of that case, I think it would be good now to turn to the flip side. So what does not constitute bullying? And the main thing to look at here in terms of the distinction between bullying conduct and non-bullying conduct is that management action carried out in a reasonable manner will not constitute bullying. This is because the Act operates on the assumption that employees have rights and obligations to take appropriate management action and make daily decisions regarding the appropriate management of employees and the business. Looked at a high level, management action could be seen as kind of any daily fair and constructive feedback. And what I've put there on that slide is just a reference to some useful resources if anyone wants to have a look after the webinar around the distinction between bullying and not bullying, and that's a draft code of practice prepared by Safe Work Australia. So in terms of examples of what may constitute reasonable management action when carried out, of course, in a reasonable way, I thought we'd go through in the next slides some of the things that you may come across on a daily basis. So the first point on the slide there is setting reasonable performance goals, standards and deadlines. So in relation to daily work, when does work need to go out? When is the client expecting the work back by? The second on that is rostering and allocating working hours where the requirements are reasonable. So every business will go through periods of having a lot of work, being particularly busy, and periods of being a little bit quieter, and directing employees to work in that time will most often be considered reasonable management action. The third point on that slide there is transferring a worker for operational reasons. So transferring a worker from one team to another or perhaps interstate. The fourth point there is deciding not to select a worker for promotion where a reasonable process is followed and documented. Some other things which will constitute reasonable management action on this next slide include informing a worker about unsatisfactory work performance, so general performance management to ensure that everyone's kind of up to scratch on their roles. The 6th point there, informing a worker about inappropriate behaviour in an objective and confidential way. So an example of that might be ensuring that an employee is following company policy or, for example, a company code of conduct. The 7th point on the slide here is implementing organisational changes or restructuring, which businesses need to do from time to time. And the 8th point here is termination, so the turnover of labour in a business. All of these things carried out in a reasonable manner will generally be considered reasonable management action and not bullying. So what I thought we could do at this point, now that we've kind of been through some of the aspects of bullying and identifying bullying conduct, is do a quiz that we've prepared for you. If everyone has a copy of the quiz in front of them, I'll just quickly explain how it should be carried out. So what we've got here is a table, and it's a yes or no answer. Of course, some of the examples in here are quite simplified, and for that reason, everyone should assume for the purposes of the quiz that all of the conduct has been repeated over time. After everyone's completed the quiz, everyone on your end can go through some of the answers together and discuss kind of how you got to those answers and whether there's disagreement on any of the points. And after that, it may be that you can come back to the webinar and I'll continue the presentation then. So if you'd like to pause the webinar now, Daphne, what I'll do is I'll just go offline for a minute or so to give you time to pause, and then I'll come back so that after you've completed the quiz, you can restart the webinar. Okay everyone, welcome back to the webinar. I'll continue to move through the presentation now that everyone's had an opportunity to kind of test some of the knowledge that we've spoken about today through the quiz. So one of the other important new aspects of the jurisdiction, which is great for everyone to understand, is the types of remedies that can be handed down by the Fair Work Commission. So the orders that the Commission can make if it does find that bullying conduct has taken place. So that's the first point on this slide. If the Commission is satisfied that a worker has been bullied at work by an individual or by a group of individuals, so for example in a worker's team, and there is a risk that the worker will continue to be bullied at work, orders can be made. The orders have been colloquially referred to as stop bullying orders, which means that they're essentially made to prevent the worker from being bullied at work. The orders can be made to apply to the employer, so to the company or the entity employing the employees, to co-workers in the workplace, particularly where bullying conduct has been conducted by a group of individuals, or even visitors. So the Commission has broad scope there to make these orders in relation to a number of people who may be present in the workplace. One important thing to note is that unlike other jurisdictions under the Fair Work Act, the Commission can't order reinstatement for employees, nor can the Commission order the payment of compensation to employees or any pecuniary amount. Moving on, I suppose, to the types of stop bullying orders that the Commission might make. The first one there is an order that the individual or group stop the alleged behaviour. A simple order there might be if the bullying conduct, for example, was unreasonably overloading one employee in your team with a lot of work when other members of the team who are capable of doing the same work have capacity. That might be the content of an order, to stop that conduct, to stop that overwork and prevent the bullying behaviour. The second type of order the Commission might make, which is on this slide, is the regular monitoring of behaviour. An example of that might be that if the alleged bully was, for example, an employee's manager, it might involve the manager of that manager sitting down with that employee from time to time to monitor, I suppose, any steps that they've taken to rectify their behaviour. And the orders of the Commission, from the language of the Act, can be as detailed, as prescriptive as the Commission sees fit. The third one there is an order requiring compliance with a bullying policy. So, for example, if a bullying policy sets out certain steps that the employer must take in particular circumstances, for example, where a grievance is raised, then the orders might require the employer to follow their own internal processes moving forward. The fourth one there, which is unlikely to be kind of relevant to Vesture, is review of the bullying policy, and that might apply, for example, where an employer prior to the claim being brought didn't have a bullying policy at all, and the Fair Work Commission might make an order that they implement a policy and induct all employees in that policy. And another type of order there on that slide is the provision of information and additional support to employees in the workplace, which might include something like the training session we're conducting today into bullying and what that means. As at today's date, we've had one decision handed down by the Commission, which I referred to earlier, in terms of the new jurisdiction. The decision itself didn't set out details of the type of conduct which was alleged, and the nature of the proceedings. However, what the decision does give us is an interesting insight into the types of orders that the Commission might make in particular circumstances. So in this decision, the orders which were handed down by the Commission were that the alleged bully must complete any exercise at the employer's premises before 8 a.m. The alleged bully was to have no contact with the applicant alone at any time. The alleged bully was to make no comment about the applicant's clothes or appearance. The bully was to not send any emails or texts to the applicant except in emergency situations. And the bully was not to raise any work issues with the applicant without notifying the chief operating officer of the employer or the CEO's subordinate before approaching the applicant. In addition to that, orders were made also in relation to the applicant's conduct, and the applicant was ordered not to arrive at work before 8:15 a.m. each day. So now that we've had a look at the bullying jurisdiction at a high level, so some of the parts of the Act and some of the ways that the Commission has already started to interpret those provisions of the Act, I thought it would be a good idea to talk more specifically about the policy that Vesture has in its business around bullying. So if everyone could please open up that bullying policy in front of them, and we can go through, I suppose, some of the key aspects of the policy and some of the things that I'd recommend you go away after today's session and have a more detailed read of. So the first thing that's really important to look at in the policy is the policy's definition of bullying. So we see that there on the first page of the bullying policy under the heading, "What is bullying?" The policy states that bullying means repeated and unreasonable behaviour directed towards a worker or a group of workers that creates a risk to health and safety. So we've talked about some of those things today, and some of those things have been touched on in the quiz. And I think one of the most important requirements there is that the behaviour itself be repeated and unreasonable. So generally speaking, bullying behaviour will not... a once-off incident will not amount to bullying behaviour, although that behaviour may be considered harassment. The policy does deal with single incidents of unreasonable behaviour at the bottom of that first page of the policy, and states that even though a single incident is unlikely to be considered bullying, will not be considered bullying, that incident may nevertheless present a risk to health and safety and is not going to be tolerated in the workplace. So that's important to remember. One of the other important things about this policy and the definition of bullying is for employees and other workers who may be present at the workplace to remember that workplace bullying can occur in any forum. So when we think about bullying, we traditionally think about face-to-face conduct. But I suppose in the way that we operate now, in the way that we interact with colleagues as well as clients, bullying could also take place by way of workplace gossip, by way of email, text messaging between colleagues, or text messaging between employees and clients. Bullying can also take place in internet chat rooms, whether directly linked to work or not, and on social media platforms, for example, Facebook. If we look at some of the other aspects of the workplace bullying policy which are important, and I've highlighted on this slide, the process for reporting bullying, that falls outside of this workplace bullying policy itself and is rather in a grievance handling policy, which we'll talk about later in this webinar. That's the same there with the process for responding to reports of bullying for managers, as well as accountability and contact points. One of the important things about the policy in terms of accountability is the responsibilities that workers have in the workplace themselves. So in order to create a safe working environment, Vesture expects that workers, and this is on the second page of the policy, will not engage in bullying, will not aid, abet, or encourage other people, including other workers, to engage in bullying. Vesture also expects that workers will report any instances of bullying when they become aware of those instances to their managers or other appropriate people identified in the grievance handling policy, and that workers will behave in a responsible and professional manner towards each other and also towards third parties, such as clients or students in the workplace, for example. So that brings an end to, I suppose, the bullying directed part of today's webinar. As I kind of highlighted and flagged at the beginning of today's session, there are two also very important areas of law which are closely connected to bullying and also tie into the grievance handling procedures, which I thought I'd just touch on today so that bullying is given its full context. The first of those areas of law is anti-discrimination. So at a very high level, discrimination will take place where someone is treated unfairly because they belong to a particular group of people or have a particular characteristic which is protected at law. At a high level, again, some of those areas that are protected by law and those characteristics which the law will consider to be discriminatory are set out in this slide. So the first there is disability. There's also sex, gender. The third there is race, as well as age, carers' responsibilities, so parental responsibilities, marital or domestic status, sexuality, transgender status, infectious diseases, and also a catch-all there that people can't be discriminated against because any of their relatives or associates have any of those attributes above which are protected by law. One of the important things to consider around discrimination is really how it can occur, because discriminatory conduct can take some overt and also subtle forms. The most important distinction in this area of law is that between direct discrimination, so discrimination based on the treatment of a particular person or particular people. And indirect discrimination being discrimination on the basis of the impact that particular treatment may have on a person or a group of people. Looking more closely at those two types of discrimination, the first is direct discrimination. So direct discrimination can generally manifest itself in two ways. The first of those ways is that of a blanket exclusion. So discriminatory conduct might be something like the employer requiring any job applicants to be men who are at least over the age of 40. That would be discrimination there on the basis of gender as well as discrimination on the basis of age. A more subtle form of direct discrimination is what's often referred to as different treatment. So an example of this might be where the employer believes that new mothers shouldn't be going away on overnight business trips, but the employer doesn't make the same judgment call about a new father. So to summarise in terms of direct discrimination, I would see this as treating someone less favourably than a similarly suited comparator because of one of those protected traits that we went through before. By contrast, indirect discrimination is concerned with the impact of conduct on a person, and specifically the disproportionate impact that an apparently neutral rule may have on a protected person or a protected group of people because of their shared traits or characteristics. So the question with indirect discrimination is not simply whether a requirement has been applied consistently across the board, but whether the requirement is fair. So if a requirement, condition, or practice operates to exclude a group, even if it does not exclude every member of that group, indirect discrimination will require an employer to examine whether the requirement is reasonable in the circumstances. Vesture also has an anti-discrimination and harassment policy which touches on some of these points. And although we won't be going through this in detail in today's webinar, I'd recommend that everyone goes away after today and has a read of how that policy might apply to their employment. The final area, substantive area before we move on to the grievance handling procedures, is that of harassment. Harassment takes place when a person is subject to behaviour that the person does not want, offends, humiliates, or intimidates the person, creates a hostile environment, and targets the person because the person has specific characteristics which might include some of the characteristics we've talked about earlier, so sex, pregnancy, race, age are some of those examples. Unlike bullying, conduct which constitutes harassment can occur on a once-off basis. It's important also to remember that instances of harassment might also take place outside of the primary place of work, for example, at a work-related social function, or if an employee makes unwelcome phone calls to another employee after business hours. One of the most important areas of harassment for everyone to understand is sexual harassment. So at law, the definition of sexual harassment is on this slide. So it's where a person makes an unwelcome sexual advance or an unwelcome request for sexual favours to the person being harassed. Where that conduct is unwelcome conduct of a sexual nature in relation to the person being harassed, and where in all of the circumstances, a reasonable person having regard to the circumstances would have anticipated the possibility that the person to whom this conduct was directed would feel harassed, offended, humiliated, or intimidated. Based on this definition, some of the types of conduct which might fall in the ambit of sexual harassment include sexual comments to other employees in the workplace, intrusive invitations to go out socially, exposure to sexually explicit magazines, posters, etc. in the workplace. It's also important to remember that conduct which is sexual harassment can also be a criminal offence, and some of those types of conduct are on the serious end and include assault, indecent exposure, and stalking. All of that said, ultimately, whether conduct amounts to sexual harassment will depend on the context of the particular case and the circumstances in each situation. And again, that was just a brief overview of the area of harassment, and I'd recommend that everyone goes away after this and has a read of the anti-discrimination and harassment policy, which deals with many of these points. So the final part of today's webinar, which everyone will be attending, is just to have a quick overview of Vesture's grievance handling policy. The importance of this grievance handling policy is that it sets out the process which everyone can follow, either if they have a grievance in relation to their own employment or their own engagement with Vesture, or if they observe conduct which they're concerned about and want to raise with someone. So if we look firstly at the steps available to workers when raising a grievance. The policy gives a number of steps that employees can take, and these can be tailored to the nature of the grievance and what you may or may not feel comfortable doing in the situation. So the first step in the policy on the first page there is to speak to the person causing the problem, where of course the employee feels comfortable doing so. This step may be an appropriate step where an employee or another worker is suffering a grievance where the other person may not be aware that they had upset the employee or the worker in that way. However, this step will obviously not be appropriate where the employee or the worker bringing the grievance has concerns about approaching that person directly. In those circumstances, employees or workers can follow any of the other three steps in the policy. So the second step there is to speak to the worker's manager, so to your direct manager. The third step there is to speak to the HR manager or the general manager of business. And the fourth step is to make a formal complaint. So if we look at that step more closely, the step of making a formal complaint may be appropriate where you've experienced something that you're particularly concerned about in the workplace. The formal complaint must be made in writing and addressed to the HR manager or the general manager of the business. The complaint should contain a description of the matter, so including any persons who may have witnessed the conduct and who's subject of the complaint, and as well as being signed and dated by you. At this stage of the process, or at any other stage of the process, employees may bring a support person along to the meetings, which will obviously assist in making complaints, which can often be difficult. One of the other aspects which is really important about this grievance handling policy is details about how the issue will be handled. And in this point, I just wanted to focus on one aspect of the policy, which is confidentiality. So what the policy says is that if you come forward with a grievance, you will not be treated unfairly, or you won't be victimised by the fact that you've made a complaint, and Vesture will treat all grievances in a confidential manner to the extent that this is permitted by law and to the extent that this is possible in the context of Vesture investigating into the conduct that you're bringing the grievance about. By the same token, it's also important that as a person bringing a complaint, you maintain confidentiality about the grievance, or if you're a witness to any of the conduct, you maintain confidentiality throughout the investigation process, as this really assists in the investigation process and making sure that impartial outcomes are reached. So that brings us to the end of the first part of this session, which is for everyone. I hope you've all taken away some useful points about bullying, discrimination and harassment in the workplace, and how the policies that Vesture has in place impact on you and how you can use them if you do suffer a grievance in the workplace. If anyone does have any questions, those can be directed to Daphne, who may then pass those on to me if there's any kind of questions arising out of today's webinar. So thank you very much, everyone, for listening today.